Hello guys, our today's topic is kinds of contracts from point of view of enforceability. So from the point of view of enforceability, a contract may be valid or voidable or void or unenforceable or illegal. Now the very first type of contract is valid contract. A valid contract is an agreement enforceable by law. An agreement becomes enforceable by law when all the essential elements of a valid contract are present. Now the second one is voidable contract, an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or the others is a voidable contract. Thus a voidable contract is one which is enforceable by law at the option of one of the parties, until it is voided or rescinded by the party entitled to do so by exercising his option in that behalf, it is a valid contract. Now the question arises when contract becomes voidable. Usually a contract becomes voidable when the consent of one of the parties to the contract is obtained by coercion, undue influence, misrepresentation or fraud. Such a contract is voidable at the option of the aggrieved party, that is the party whose consent was so caused. But the aggrieved party must exercise his option of rejecting the contract within a reasonable time and before the rights of third parties intervene. Otherwise, the contract cannot be repudiated. Now, let me explain you with an example. Suppose Mr. A threatens to shoot Mr. B if he doesn't sell his new scooter to A for rupees 2000. B agrees. The contract has been brought about by coercion and is avoidable at the option of B. Now there is another example. Uh, Let me explain you. Mr. A, intending to deceive Mr. B, falsely represent that 500 quintals of indigo are made annually at Mr. A's factory, and thereby induces Mr. B to buy the factory. The contract has been caused by fraud and is viable at the option of Mr. B. Contract Act has laid down certain other situations also under which a contract becomes voidable. For example, number one, when a contract contains reciprocal promises and one party to the contract prevents the other from performing his promise, then the contract becomes voidable at the option of the parties who prevent it. Let me explain you. A contracts with B that A shall whitewash B's house for rupees 100. A is ready and willing to execute the work accordingly, but B prevents him from doing so. The contract becomes voidable at the option of A. And now the number two is when a party to the contract promises to do a certain thing within a specified time but fails to do it, then the contract becomes voidable at the option of the promisee if the intention of the parties was that time should be of the essence of the contract. Let me explain you. X agrees to sell and deliver 10 bags of wheat to Y for rupees 2500 within 1 week, but X doesn't supply the wheat within the specified time. The contract becomes voidable at the option of Y. Now let me explain you the consequences of rescission of voidable contract. Section 64 lays down the rights and obligation of the parties to a voidable contract after it is rescinded. The section states that when a person at whose option a contract is voidable rescinds it, the other party thereto need not perform any promise therein contained in which he is a promiser. If the party rescinding a voidable contract has received any benefit from another party to such a contract, he must restore such benefits so far as may be to the person from whom it was received. For example, when a contract for a sale of a house is avoided on the ground of undue influence, any money received on account of the price must be refunded. Notice that the section aims at placing both the parties to a voidable contract after its rescission on the same footing as for there had been no contract at all. But it must be remembered that the benefit which is to be restored must have been received under the contract. If an amount has been received as a security for the due performance of the contract, such earnest money deposit is not to be returned if the contract becomes voidable under Section 55 on account of the promiser's failure to complete the contract at the time agreed and has been rescinded by the promisee. because it is not a benefit received under the contract. So far, we have studied valid contract and voidable contract. Now, the third kind of contract from the point of view of enforceability is a void contract. So let me explain you the void contract. Literally, the word void means not binding in law. Accordingly, the term void contract implies a useless contract which has no legal effect at all. Such a contract is a nullity as for there has been no contract at all. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. It follows from the definition that a void contract is not void from its inception and that it is valid and binding on the parties when originally entered, but subsequent to its formation it becomes invalid and destitute of legal effect because of certain reasons. Now let me explain you the reasons which transform a valid contract into a void contract as given in the Contract Act. Number one is supervening impossibility. A contract becomes void by impossibility of performance after the formation of the contract. For example, A and B contracts to marry each other. Before the time fixed for the marriage, A goes mad. The contract to marry becomes void. Number two is subsequent illegality. A contract also becomes void by subsequent illegality. For example, A agrees to sell B 100 bags of wheat at rupees 650 per bag. Before delivery, the contract bans private trading in wheat. The contract becomes void. Number third is repudiation of a voidable contract. A voidable contract becomes void when the party whose consent is not free repudiates the contract. For example, M by threatening to murder B's son makes B agree to sell his car worth rupees 30,000 for a sum of rupees 10,000 only. The contract being the result of coercion is voidable at the option of B. B may either affirm or reject the contract. In case B decides to rescind the contract, it becomes void. Now the number fourth is in the case of a contract contingent on the happening of an uncertain future event if that event becomes impossible. A contingent contract to do or not to do something on the happening of an uncertain future event becomes void when the event becomes impossible. For example, A contracts to give rupees 1000 as loan to B. If B marries C, C dies without being married to B. The contract becomes void. Now the fourth one is unenforceable contract. An unenforceable contract is one which is valid in itself but is not capable of being enforced in a court of law because of some technical defects such as absence of writing, registration, requisite stem, etc., or time barred by the law of limitation. For example, an oral arbitration agreement is unenforceable because the law requires an arbitration agreement to be in writing. Similarly, a bill of exchange or promissory note, though valid in itself, becomes unenforceable after 3 years from the date the bill or note falls due, being time barred under the Limitation Act. Now, the fifth one is illegal or unlawful contract. The word illegal means contrary to law, and the term contract means an agreement enforceable by law. As such, to speak of an illegal contract involves a contradiction in terms because it means something like this: an agreement enforceable by law and contrary to law. There is apparent contradiction in terms. Moreover, being of unlawful nature, such an agreement can never attain the status of a contract. Thus, it will be proper if we use the term illegal agreement in place of illegal contract. An illegal agreement is void ab initio. An agreement is illegal and void if its object or consideration is forbidden by law or is of such a nature that, if permitted, it would defeat the provisions of any law or is fraudulent or involves or imply injury to the person or property of another, or the court regards it as immoral or opposed to public policy. Thus, an agreement to commit murder or assault or robbery or to make a gift in consideration of illicit intercourse would be illegal and void ab initio.